Department T is back in session and ready to proceed with closing arguments on the Ignacio Avila Jr. versus Rosie Martinez and Henry Oliva matter, case number D-155155892-C. Are counsel and Rosie ready to proceed with their closing arguments?
Yes, I am, Your Honor.
Thank you. Mr. Medlin, are you ready to proceed as well?
I'm sorry, yes, Your Honor.
Okay, perfect. Please proceed, counsel.
Okay. While this case is clearly an emotionally fraught one, today's evidentiary hearing concerns one legal issue, which is Ignacio Avila's paternity of Alan. The evidence presented today has shown that from the time Rosie was pregnant with Alan, Rosie and Henry have deliberately and consistently lied to Ignacio regarding the possibility that Alan could be Ignacio's son. In so doing, the defendants have stripped Ignacio of his fundamental right to parent Alan and watch him grow. Now, 9 years after Alan was born and 9 years after Rosie and Henry submitted a fraudulent acknowledgement of paternity of Alan, defendant Henry alleges that this court's confirmation of paternity would strip him of his parental rights. Unfortunately for him, Henry, does not have any legal parental right over Alan. First, I want to talk about the law of the case. The Nevada Supreme Court has long held that where an appellate court deciding an appeal states a principle or rule of law necessary to the decision, the principle or rule becomes the law of the case and must be adhered to throughout its subsequent progress, both in the lower court and upon subsequent appeal. This mandate is known as the law of the case doctrine. The district court commits an error if an order on remand contradicts the appeal court's decision. Here, the Supreme Court of the state issued an order of reversal and remand on January 23, 2020, instructing this court to follow the procedures specified in NRS Chapter 126 to determine the issue of paternity. Accordingly, the law of this case is that paternity must be determined under NRS 126 and the presumptions provided therein. Contrary to opposing counsel's argument earlier that this is not a black and white issue, with respect to the paternity, it very much is black and white. Every student in their first year of law school learns that the first place to look when interpreting a statute is the plain meaning of that statute. Here, a plain reading of NRS 26 provides that the liberty interest of a parent in the care, custody, and management of the parent's child is a fundamental right. NRS 126.051 provides for presumptions of paternity. Subsection 1 of this chapter, read together with subsection 3, provides for a rebuttable presumption for paternity, which can be rebutted by clear and convincing evidence. Moreover, subsection 3 provides that where two or more presumptions arise which conflict, the presumption founded on, quote, weightier considerations of policy and logic controls. Subsection 2 of this chapter provides for a conclusive presumption where genetic testing reveals that a man is the biological father of a child with 99% probability or greater. A rebuttable presumption is defined by Black's Law Dictionary as an inference drawn from certain facts that establish a prima facie case, which may be overcome by the introduction of contrary evidence. A conclusive presumption, on the other hand, is defined by Black's Law Dictionary as a presumption that cannot be overcome by any additional evidence or argument because it is accepted as irrefutable proof that establishes a fact beyond dispute. Here, Ignacio has submitted one DNA test to this court and has had two others completed, which show within 99.9999% probability that he is Alan's father. Ignacio presented a paternity test at this court's own direction, so he's following the law of this case in so doing. Even absent this conclusive presumption, the other presumptions have been rebutted by clear and convincing evidence of fraud. Specifically, that Ignacio confronted Rosie and Henry about Alan's paternity in about 2016 or 2017, and was lied to and told that there was no possibility that Alan was his child. Even a few weeks after Alan's birth, Ignacio asked Rosie whether Alan was his child or could be his child, and Rosie told him there was no possibility of that. A party who has lied should not be entitled to a presumption of paternity by their own fraud. In this case, the fraudulent birth certificates and the fraudulent holding out of Alan as Henry's own son. Now, with respect to the relevant case law, that's the plain reading of the statute. We really don't need to go much further than that, but obviously other cases have been raised interpreting this. So moving on to Love v. Love, which was cited by opposing counsel in the pretrial memo of Henry. In Love v. Love, Love v. Love involved a father who learned late in a child's life that he was not the father, and he only raised the issue of paternity 2 years after he had a DNA test completed. The reason that he raised paternity as an issue was to claim that he was not the child's father and to evade mom's motion for child support modification based on his increased income. In contrast to the presumptive father in Love v. Love, Ignacio is asking this court to use a DNA test to find that he is the father of his child, not to disestablish paternity or evade his obligation for support of Alan. Moreover, the presumptive father in Love took a DNA test, discovered he was not the child's father, and then sat on the results until the mother requested to modify child support. Here, again, as soon as Ignacio realized that he might be Alan's father, he confronted Rosie and Henry and asked whether they had ever done a paternity test. Shortly thereafter, he conducted 2 paternity tests on his own and then raised this issue with the court so that the court could intervene and help establish paternity in this case. Next, the court held in Love that a decision of paternity will not operate as res judicata where extrinsic fraud existed in the original proceeding. Thus, Henry's claim that the children's birth certificate and his completion of a voluntary acknowledgement of paternity preclude Ignacio from claiming paternity is unpersuasive. The messages presented today between Ignacio and Henry show clearly that Henry and Rosie conspired to conceal from Ignacio that he might be Alan's father. Finally, Love v. Love was decided in 1998 before a conclusive presumption of paternity was added to NRS 126051 in 2007. Opposing counsel would like to cite to Love in a vacuum and say that DNA is not controlling. And while that was one sentence that was used in Love v. Love, we need to look at the broader context. Specifically, the Supreme Court in Love noted that NRS 126.051 does not set forth conclusive presumptions of paternity. The statutory scheme clearly reflects the legislature's intent to allow non-biological factors to become critical in a paternity determination, just as opposing counsel is arguing today. However, in 2007, Assembly Bill 498 added subsection 2 to this chapter and specifically added language to subsection 3, which was formerly the second subsection, providing that only presumptions under subsection 1, rather than in this chapter, are rebuttable. The Supreme Court in Love held explicitly that the legislature has the power to decide that the results of biological tests do not conclusively determine a paternity action. So, the court's holding in Love actually supports Ignacio's claim today, which is that the legislature amended NRS 126 in 2007 to provide that the results of a biological test do conclusively determine a paternity action. Therefore, Love is not controlling. The legislature has spoken on this issue, and it has spoken quite clearly. Moving on to the second case cited by opposing counsel, which is St. Mary versus Damon. Again, St. Mary involved 2 mothers, a surrogacy, and a co-parenting agreement that was entered prior to the child's birth. This case is simply not analogous, and the court doesn't need to consider best interest factors because the paternity presumption in favor of a DNA test is conclusive. There does not need to be any additional evidence heard. To opposing counsel's point of a de facto agreement between the parties, Ignacio's good co-parenting and his willingness to accommodate Rosie's time are not an agreement when he did not even know that he had rights to Alan. So to say that he agreed to some sort of schedule is simply unpersuasive when you look at the evidence and you see that as soon as he learned that Alan could be his child in 2017, he began asking for his rightful timeshare of him. There was no agreement that Henry was a third parent or even a party to this case. That was a court order which joined him to this case. Now, I understand that, again, the emotions are high in this case. Unfortunately, the law is not whoever loves Alan is a parent. That's not the law. The laws are written by the legislature for a reason, and the law is very clear on this point that when the DNA test proves that one person is the father conclusively, that cannot be rebutted. Now, with respect to third-party standing, my client requests that Henry, whatever his arguments may be for custody or visitation, they're not properly pled here because he does not have paternal rights. So I want to discuss a little bit about third-party standing. The Nevada Supreme Court held in Silva v. Mathis that even in the absence of an adoptive or biological relationship, a party may have standing to seek custody of a minor child under NRS 125C. So, absent biological paternity, a third party can still request custody. A non-parent custodian has 3 avenues available to him to maintain a legal relationship with the minor child. Again, the first is parentage, which we just established is not viable. The second is third-party custody, and the third is third-party visitation. Here, like the appellant in Silva, Henry's presumptive paternity is defeated by Ignacio's conclusive paternity. Therefore, he lacks standing to challenge or petition for paternity of either Jaslyn or Alan. Therefore, parentage is not a viable avenue. However, unlike the appellant in Silva, Henry does not even have standing to pursue a claim for third-party custody under NRS 125C.004 because he has not alleged that an award of custody to Ignacio would be detrimental to the child. Therefore, third-party custody is also not a viable avenue. Finally, even under NRS 125C.050, a non-parent may pursue reasonable visitation rights only if a parent of the child has denied or unreasonably restricted visits with the child, with the child. So, in other words, the parent needs to have restricted the third party's ability to visit with the child. Here, as the evidence has indicated and as the court has heard, Ignacio is the party who has been restricted from visitation by Henry and Rosie. Henry has not been restricted visitation with Alan. Accordingly, if this court confirms paternity of Alan to Ignacio, Henry should be dismissed from this action in order to pursue any claims he may have to visitation with Alan or Jaslyn under NRS 125C, the statute providing for a non-parent's right to petition for visitation. Now, obviously, this court may take this issue under advisement. There's a lot to review. In the interim, my client respectfully asks that this court enter temporary orders awarding him joint physical custody of Alan. NRS 125C.00253 provides that the court shall award physical custody in the following order of preference unless in a particular case the best interest of the child requires otherwise. The first priority for preference of physical custody is to both parents jointly pursuant to NRS 125C. NRS 125C also provides that during the pendency of an action, the court may make any such order for the custody, care, education, or maintenance of the child as appears in his or her best interest. Of course, the ultimate concern of the court is the best interest of the children. Like I said, there's a preference for parents to be awarded joint physical custody first. A step-parent relationship does not give that parent, that purported parent, no matter whether he calls himself dad or not, rights. And additionally, Ignacio has not said that he will stop letting Henry see the minor child. He has never said that he would restrict visits with Henry. He simply wants the custody that he is entitled to under the law. I also want to point out that it's curious that when Henry was deemed the legal father by the court, Henry and Rosie conspired to decline and decrease Ignacio's visits, not letting him visit overnight anymore and only letting him see, by Rosie's own testimony, at exchanges of Jaslyn for just a few moments here and there. Now that Ignacio's paternity may be confirmed, they would like to penalize him for not agreeing to a generous schedule. That's not Ignacio's burden. You also heard testimony that Henry and Rosie have a great co-parenting relationship, but again, the co-parents in this case should be Rosie and Ignacio, and those two need to collaborate to come up with a schedule that is in the children's and specifically in Alan's best interest. With that being said, Your Honor, I also would like to point out that one of the most relevant considerations for this court under the best interest factors is whether a parent has withheld or tried to frustrate another parent's relationship with that child. I think the evidence today has pretty clearly shown that Rosie and Henry have conspired, and again, if Henry's doesn't have any responsibility in this case, then Rosie really has allowed for Henry to have time with Alan, to which he's not legally entitled. Of course, Henry is upset. This is a complicated case. This case affects 3 children and 3 parents, but that is not Ignacio's fault. Rosie and Henry would like to align and say that Ignacio is the one who is causing frustration in this case, and that he is the reason that this case is not settled. The reality, however, is that Ignacio was not even given the option to settle until his own son was 6.5 years old. And even after that time, once Henry was confirmed to be the legal father, he was again cut out and not offered any opportunity to settle this case. I think it's pretty evident, Your Honor, that Rosie and Henry are now scrambling to say that they would love to settle with Ignacio because they realize that it's possible that Ignacio will have joint custody of his son. I hope that the court sees through that and sees that Ignacio has been the party who has been trying to make things right with respect to Alan. Again, the Supreme Court intervened, and Ignacio has now lost 9 years with his son, and Henry and Rosie would like to penalize him for asking for time with his son now that he knows conclusively, without a doubt, that he is Alan's father. To allow Henry and Rosie to share some sort of custody when Ignacio is clearly Alan's father biologically and under the law would be not only contradictory to Nevada law on this issue, but it would also be inequitable, and it would strip Ignacio of his fundamental right to parent. Thank you, Your Honor. Oh, I'm sorry. I needed to mention the schedule that my client would request. He requests a joint physical custody schedule with Rosie, with each party having 3.5 days, with the exchanges taking place at the child's school. If that's not amenable and the court prefers to do a cleaner schedule, he would be amenable to a week-on, week-off schedule such that Rosie could split the week with Henry if she so desires, but so that his time remains intact. Thank you, Judge.
Thank you. Mr. Medlin.
Yes, Your Honor, there was a lot to unpack there. But while the court is familiar with my arguments on the law, I think it's more important to discuss the matters of the facts. We could have raised matters of law, including a Rule 41B involuntary dismissal of the action for the plaintiff's failure to comply with the court's order in achieving a guardian ad litem so that these children could have a voice. Instead, plaintiff elected for his rights. And again, we'll see that theme throughout the entirety of the action, as you have seen all day today. In doing so, he is in contempt of court, and the evidence should weigh even heavier against him for what would be in the best interest test of the children. Counsel believes that does not apply. However, NRS 126 is very clear that there are weighty considerations of policy and logic which control any decision of paternity. I have cited to a California appellate case, previously cited by the Nevada Supreme Court, giving a bench line of 3 years, wherein a child can develop quite an attachment because it doesn't take very much to be a father. It takes, I believe that's a crass comment. It does not take very much to be a biological father, but it takes a lot to be a dad. It takes a lot to be a dada. It requires the effort towards the children's schooling, towards their religion, towards their raising. That is why in NRS 126 at 053, the voluntary acknowledgement of paternity gets its own section while counsel would like to point to a clause that is conclusive, a voluntary acknowledgement is one man stepping up from the crowd saying, yes, I will take care of them. And even if parentage is in doubt, he will still take care of them. And that is what it takes to be a dad. Plaintiff hasn't made efforts. We have heard testimony that he made one phone call towards school, that he retributively pulled the youngest out of religious schooling, and that's because he is interested in only one thing, his black and white legal rights. But the black and white legal rights are not as black and white as plaintiff's counsel would like to paint them. There is those weighty considerations of policy and logic that must be factored into in a paternity action. While they cite a change in the legislation from 2007, the 2013 case delved right back into those weighty considerations of policy and logic. They might be differential on the facts, there might be, but the facts here are quite disparate. The common theme, though, in all of family law, paternity actions, all the way going back to Love v. Love, and even with the legislature's amendments, remains to be the best interest of the children. What have they been living under to get to this point? How have they been treated? Your Honor heard testimony that the children are bothered after their interactions with plaintiffs. Heard allegations that the plaintiff has discussed paternity improperly with a minor who is subject to these proceedings and might otherwise be engaged in nefarious sorts of brainwashing, which are alleged. I think that doesn't even need to be reached. All that needs to be reached is the actual day-to-day care and concern of these kids, the factors of keeping them together as much as possible, the factors of keeping them with their siblings, which, shame on all the parents my client included, their siblings are their rocks, their available brothers, literally, to face through this mire that the adults have created. In doing so, while our fallback position is visitation, we don't believe that we are required to fall back that far. Plaintiff has failed their burden in clear and convincing evidence of showing why his designation of paternity would be good for the children. We heard that it was, technically, 99%. We won't even argue that point. We have a test. But that does not meet clear and convincing evidence. They did not push this boulder all the way up the hill to show that he is a dad, is a good dad, and cares for this child who has been cared for by my client since. My client signed a voluntary acknowledgement of paternity, is on the birth certificates, was cohabitating with the natural mother, and even after this action, has raised these kids. My client is the legal father and entitled to those presumptions which he has shown through his conduct and the facts Your Honor has heard. And it is up to you to weigh the weighty considerations of policy and logic in picking whether one of these fathers is more invested in the actual well-being of the children and which one is entitled to his time and rights and technical designations. Thank you.
Any short reply, Ms. Locks?
Yes, Judge, just very briefly, I want to talk about the policy and logic considerations. Again, our request for paternity to be established is based on a black and white statute, but it is based on a fundamental right of a parent to have custody and care of their children. So this isn't some, I'm reading the statute too strictly or I'm being technical. This is a fundamental right all of us have to parent our children when we birth them or when we contribute to their being born. And my client has been stripped of that. And to say that, Henry has shown up, and I believe he has. I don't doubt for a second that he's been an excellent figure in these kids' lives. That being said, he perpetrated a fraud which has resulted in him holding out Alan as his own child. And that should not be allowed under public policy of fundamental rights to parent. And that's all I'll say on that. Thank you, Judge.
Thank you. One second. Okay. The court is ready to make a decision. I know it's Friday, and I know Ms. Locke said that. Sorry, it's not Friday. Is it Friday? Is it Friday? Happy Friday.
It is Friday.
Counsel said that the court might take this matter under advisement, and I think that this case screams a need for finality, so I want to provide that to the parents. Ms. Locke, I'd like you to prepare the final order, and please include findings of fact and conclusions of law. The court cannot go outside of the law and make decisions. The court has to start with the law and make a decision starting from that point. And it is incredibly difficult and sad to see what's happened, but the court finds that none of the things that have happened are Ignacio's fault. And he's innocent in this particular case, as much as Alan is innocent. Pursuant to NRS 126.051, subsection 2, the paternity test that was finally ordered and accepted by the Nevada Supreme Court and confirmed in this case in 2020 is conclusive. And that means that Ignacio Avila Jr. is conclusively the biological father and legal father of Alan. The court makes a finding that Ignacio confronted mom in 2016 and 17 and was lied to. The court makes a finding that Ignacio asked after the child's birth and even while mom was pregnant about the child, Alan, and was lied to again. The court finds that at 11:50 a.m. today, mom lied to the court 2 times. The court finds that the birth certificates need to be amended to reflect the name of Ignacio Avila Jr. The court is not going to make a finding that Henry's paternity test and the text message string is a fraud because the court doesn't have enough for that, and the court doesn't care to go down that path. The court is going to also make a finding regarding the voluntary acknowledgement of paternity. Pursuant to NRS 126.053, that governs voluntary acknowledgements of paternity or parentage. Under subsection 3, after the expiration of the period during which an acknowledgement may be rescinded, pursuant to subsection 2, the acknowledgement may not be challenged except upon the grounds of fraud, duress, or material mistake of fact. The burden of proof is on the person challenging the acknowledgement to establish that the acknowledgement was signed because of fraud, duress, or material mistake of fact. Henry, this is not your fault. I want to say that to you directly. I wish I could see your face. My heart goes out to you, but my heart goes out to Ignacio more because he's missed 9 years. Under subsection 3, the court finds that there was either material mistake of fact or fraud when Henry signed that voluntary acknowledgement of paternity. And that under NRS 126.051 subsection 2, the conclusive presumption of paternity from the paternity test that was finally done in 2020 after the Nevada Supreme Court made its decision overcomes any voluntary acknowledgement of paternity signed by a person that was not the child's biological father. The court further finds that when this matter was pending in 2018 and right before it was appealed, Mom and Henry intentionally deprived Ignacio of time with Alan. And the court finds that that withholding was affirmed in testimony by all three parties, Henry, Rosie, and Ignacio, when it was clear that Alan had had some overnights, and those overnights were suddenly taken away 3 years ago. Not only has Ignacio missed infancy and toddlerhood and young childhood, then when there's a decision in 2018, square on the head, frequent associations, that factor incredibly favors Ignacio. Counsel is correct that Ignacio was denied real settlement opportunities regarding Alan until he was 6.5 years old. Counsel for Henry indicated that there was possible contempt. There is no contempt proceeding before this court. Counsel for Henry indicated that, that contempt, in his closing argument, there is no pending order to show cause before this court, so that's not before me. The court finds that pursuant to NRS 126.081 subsection 1, paternity actions such as this are not time barred until a child reaches the age of 21. And the court finds that the paternity test is a conclusive presumption. In this particular case, the time share for Alan and Ignacio is to start immediately. The parents are to communicate, meaning Rosie and Ignacio, are to communicate as to any backpacks or things that need to be shared with Dad, but Dad, Ignacio, is going to start his timeshare as soon as court ends. The timeshare after is going to be Thursday at 2 p.m. because Dad gets off at 1 p.m. and it will end Sunday at 8 p.m. So Dad's going to have 3 overnights. And what I want you to do, Dad, I want you to seriously consider on Fridays, when you're working from 5 a.m. to 1 p.m., I want you to seriously consider picking up the phone and calling Henry and saying, hey, does Alan want to spend some time with Henry Jr. and you? I want you to seriously give that a lot of thought, and maybe you and Henry can perhaps become friendly and use that Friday to be a Henry Jr. day when you're at work. Okay, Ignacio? Do you hear me?
Your Honor.
Okay. Okay.
Yes, Your Honor.
I want to see you nodding, and I want to see you saying something. I can't imagine being in Henry's shoes right now. I think that man's heart just broke in half. So I think, and I hope, that you really, really, really think of that Friday as a Henry Jr. and Henry Day, okay? When you're at work.
Yes, Your Honor.
Okay, thank you. Miss Locks, I would like you to please prepare the final order. And the court can either do the default holiday schedule, but I would much prefer to have Ignacio and Rosie go to FMC and try to figure out holidays and vacations. Do either counsel have a preference?
Judge, maybe you could do a temporary order for the default holiday schedule and then refer them to FMC for a permanent holiday schedule.
Mr. Medlin?
I don't believe I factor into that decision.
I hear you. Rosie? I can't hear you, Mom.
You're muted.
Yes, I agree that a temporary will be okay.
Okay, where is Alan right now?
Right now, he's at the house with his brother, Henry.
Okay, he's at Henry's house?
Yes.
Okay, Ignacio, you're gonna pick them up today, okay?
What? Okay.
Okay,
Yes, Your Honor.
okay. As far as the request to change the birth certificate, so granted. As far as the request to change, the name, so granted. Ignacio, you have to give Rosie a birth certificate of her own. What I suggest is get 2 originals. I'd like you to bear the cost of that.
Yes, Your Honor.
And we will
Judge,
have
I know that
the default holiday and vacation schedule apply for now, and the court will formally ask Rosie and Ignacio to go to FMC to resolve parenting holiday and vacation time.
Yeah, Judge, I had one question. I know that this is obviously raw. The child's name on his birth certificate is, the middle name is Sergio, which is, I believe, after one of Henry's relatives, and my client wants to know if he and Rosie can cooperate to change his middle name.
What's the proposed middle name?
He would like for it to be his own name, Ignacio, but he understands that this is a co-parenting decision, so he doesn't have any connection to Sergio.
Rosie, any thoughts?
I don't want to talk about that right now.
Okay. Miss Locks, I didn't hear evidence about that. And the Nevada Supreme Court case law changing last names and, all of that requires me to hear some evidence, and I just don't have it. So, I could invite briefing and do a status check on that issue. If you would like to do that, I could set it out for 30 days and sort of see how things went at FMC, maybe 45 days. See how
That
things went.
45 days sounds good, Your Honor, and I think that'll give us time to let this issue breathe, and then maybe even Rosie and Ignacio can come to an agreement as opposed to
Right.
having to do this again. But 45-day status check would be really great.
I'm just concerned that when you prepare the final order, you won't get a signature, so then the court won't be able to see any sort of potential agreement or not with a middle name.
No, I wouldn't include this issue in the decree. I would the name change would just be the last name in the decree, and then it would be a stipulation and order if the parents agree to change his name down the road.
Okay. Okay. And then the last thing the court wants to say is to Henry. Henry, you are a person in this case that is now considered a third party. And third parties have the ability to ask for things. And if you would like to do that, this court would entertain that. But it's not going to be the kind of custodial parenting time that you're used to. It's akin to grandparent rights. It's a shorter amount of time that your lawyer can explain to you about. But there are avenues, and this case is available to do that. This will be the order of the court from today. I'm signing off on an FMC referral for Ignacio and Rosie to go to FMC to resolve holidays and vacations. And the return date is May 26th at 10 a.m. Any other
That works
questions,
for me, Honor.
counsels?
No, Your Honor.
Okay. Thank you. That will conclude today's case.
Thank you, Your Honor.
Thank you, counsel.